Welcome to the 2021 Massachusetts and Rhode Island Land Conservation Conference. This session is titled Conservation Restrictions, Avoiding Current Red Flags for the IRS in Drafting and Filing. And my name's Diana Norris. I am the Associate Director of Conservation Defense at the Land Trust Alliance. I'm also a Virginia attorney. I'll be presenting today with Steve Small, but I'll also be moderating, so I'm going to be multitasking a little bit. Stevie, do you want to go ahead and introduce yourself?
Hi, I'm Steve Small. I was going to bring with me, but I couldn't put my hands on it, the T-shirt from LTA Rally 1988. I do have it somewhere. I wore it on a call a little while ago. And so maybe that's, do I need any more introduction? The short answer
I think that's good.
For those of you who don't know me, the short answer to the question, why is he on the phone, on the call, is that from 1978 to 1982, I was in Chief Counsel's office at IRS in Washington and wrote the federal income tax regulations on conservation easements. And then, as I like to say, when I left the IRS in 1982, there was nobody else in the country that cared about that. But now it's quite clear there are a lot of people that care about it, and I think it's great. I think a couple of things. We have less than an hour, give or take, to go over some very important and very complicated current topics. I did a program for mass continuing legal education in 1988 on conservation easements, or conservation restrictions, as we call them in Massachusetts. And at the end of the 4 hours, I said, I'm really sorry. I said to the attendees, this was in person, we didn't have the answers to a lot of questions that you've asked. But I guarantee you that over the years, we'll develop those questions. Long and short is to develop those answers. And long and short is over the years, we did develop those answers as the business grew. And in the past 2 years, there have been some court decisions that have said, your answers are wrong. And so we're dealing with a lot of well-established good faith practices. There are syndicated conservation easement transactions going on out there now. That's almost all we're going to say about them here. We're talking about good faith mainstream land conservation practices, and the field is in flux because of the IRS heady presence in this field when for decades there was none, and because some of the court decisions have taken a very clear view of what enforceable in perpetuity means. It does not just mean the conservation easement has to say it's enforceable in perpetuity. So 1, 2 is this is a primer. This is a resource. We can't possibly cover everything, and I think we intentionally left out case citations because for this presentation, I think the important issues are the points that the cases make, and we're going to talk about those. But on the slide up in front of you, go to alliancerally.org for information about the LTA annual rally. We're also doing a Trying Times webinar in Utah in May. Same stuff, current stuff. It'll be a 4-hour panel. The website isn't up yet, but Google Trying Times 2021 University of Utah Law School if you want to attend that. And finally, there's a link to Trying Times article, comprehensive article. So we're going to do what we can. We're going to leave some questions unanswered. The final quick comment I want to make is perspective. 90% of my clients are private landowners, and they love their land but they also like the idea of an income tax deduction. And I see my primary job, and my comments today are going to be from my perspective, is to protect them from the IRS, to make sure that the documents that we write conform in every possible way to what the IRS is looking at right now. People in the land trust business, I think your primary goal is to conserve the resource. And that's obviously one of my primary goals too. The landowner and the land trust want to conserve the resource. I want to make sure that in the process of doing that, we follow the IRS rules. So
do you want to get started with some practice tips, Steve?
yeah, let's do some practice tips quickly. Those of you who've been to any of my programs before, by the way, how many of you out there think that 9:15 in the morning is a good time to talk about Section 178 of the Internal Revenue Code of 1986 and the regulations that are under hands? Okay, I don't see any hands. The first thing to do in any situation dealing with land, whether it's a sale of a piece of land, whether it's a donation of a conservation easement, whether it's a fee, run the title. You need to find out that the property is owned in the manner and in the form that the owner, grantor, the person you're dealing with thinks it is. 90% of the time, there's no problem. And 10% of the time, there are problems. And the reason you need to do this is there can be impediments to perpetuity on the title, in the record, like separated mineral interests, like a mortgage. Most landowners know whether there's a mortgage or not. I've run into a few situations where the people have said, well, Bob and Sally own the property, and it turns out it's the Bob and Sally Family Limited Liability Company, which requires a different level of due diligence. So that's the first practice tip. Run the title and run it early. The second one, again, is looking over my shoulder at the IRS. Pretend that the IRS is reading that conservation easement document and the baseline. And you know they're going to be reading the 82, 83, and so forth. We spend pages and pages and pages in the recitals of every single conservation easement saying how it qualifies. In the old days, it was, this is a beautiful property and Sally loves it, and therefore she's going to put an easement on it. And maybe in the old days that worked, that doesn't work anymore. How does it meet the conservation purposes test? What are the clearly delineated governmental policies? What are the photographs of the property that are included in the baseline documentation report that show the scenic view? Put that in the recitals, put it in the baseline, put it in the supplemental statement for the 82, 83, and don't even let the IRS ask the question, how does this qualify under Section 178? What are the conservation purposes that you're protecting? And Diana and I were just talking earlier about the 82, 83. One tip that seems to have eluded a lot of people. Number one, there's a new Form 82, 83 for gifts in 2020. It's not considerably different as far as we're concerned from prior ones, but use the new form. And number two, this rule seems to have escaped people, that in the rules are now that if a landowner has a carry forward of the deduction for a charitable contribution, you have to file the 8283 and the appraisal report in every year you claim the carry forward. This is great business for the people who make printing paper and for the people who print up multicolored pages and appraisals. It seems onerous, but I understand it. In 49 states, and we're going to keep this very short because I know this is Mass, Rhode Island, but I know most of you are from Massachusetts. In 49 states, the landowner signs, the holder of the easement signs, the easement goes to record. That's it. Easy enough. It may be more complicated than that, but that's the signature process. Massachusetts, we are blessed in Massachusetts, and those of you from Massachusetts know, when you'll see on the next slide, the Massachusetts process is slow, onerous, demanding, and in the end, I think, great. Those of you from Massachusetts know the process. Here's the list. The single point I want to make here is that if you want to convey a conservation easement in Rhode Island and it's October and you want to get it done by the end of the year, that's possible. Not necessarily always, but possible. In Massachusetts, the process just takes too long. And again, if you're watching this, you probably know that already, but we can't emphasize it enough. We also probably can't compliment DCS, Division of Conservation Services, where they've been reviewing conservation restriction drafts for decades and have done one great professional job. We're very, very fortunate about that. Next slide. Practice tip number 3, run the numbers. And this is a simple one to get across. Sometimes I hear land trust people saying, and sometimes I hear family members and landowners saying, well, if I donate an easement valued at $750,000, my federal income tax savings will be roughly $200,000. Please don't make generalizations like that. I know land trusts aren't supposed to provide tax or legal advice, but I hear that sometimes. And if you hear a landowner or an advisor to a landowner who's not necessarily a tax professional make that comment, tell them, please work with an advisor who has the software, who can plug in the numbers and tell you exactly what the answer is. So many of my phone conversations with new clients start off with, well, I don't know how much the deduction is going to be. I want to do this. And my recommendation is get an appraisal, short form appraisal report early, and then talk to your tax advisor and find out what the tax consequences are going to be to you. As I always say, if there's going to be an unpleasant surprise, I want to find out early. If it's going to be a pleasant surprise, that can wait. Next.
On that note, let's dive into the recent and big developments in conservation-related tax cases and the big takeaways. When Steve and I were talking, there's so much going on right now and so many nuances that really what we decided to do is work on breadth, not depth with these cases, really they're heads up and some big takeaways. Some are more straightforward than others. And while we're talking, we really want you all to think about considering what your land trust's tolerance for risk is when it comes to dealing with the IRS and the chance of audit. All right. So we're going to dive into one of the more straightforward ones, and that is the deemed approved. And Steve, it looks like I froze.
Welcome to 2021.
That's right.
People from Shanghai who are zoomed into this. The technology is marvelous, but sometimes it doesn't always work.
So, Steve, I'm going to leave and come right back, okay?
Okay.
So if you want to start talking about deemed approved, that would be great.
Okay, good. I can talk about that, and I think it's a simple one to talk about. The history of this since day one has been that it's typical in a conservation easement, and again, I'm using that term also to cover Massachusetts, even though we say conservation restrictions. It's typical to say if grantor may do A, B, and C subject to the approval of a grantee. And they're permitted activities, but you need approval. And then the next provision in the easement has been you've got to give grantee the papers, you've got to provide the necessary information. And if they don't respond within 45 days or within 60 days, whatever it might be, then your request is deemed to be approved. And that's been the practice. People have said, well, the land trust might be busy, it's going to take some time. And the IRS has been saying, no, we don't like that for a long time. And the courts finally said, no, we don't like that either. It has to be deemed denied. What's the reason? Very short and simple. If the landowner submits a request for an activity, the exercise of which would have an adverse impact on the conservation values of the property, that should not be deemed approved. That should be denied. So a very simple one-word change. It's up there on the screen. Diana, I'll turn it back to you.
Thank you. Sorry about that. Welcome to our world. I do just want to add on that the IRS has provided some sample language about the deemed approved and deemed denied, and that is in their advisory memo with the citation on the slide. So.
Although the key,
thank you, Steve,
again, it's one word. It's one word. It's deemed denied instead of deemed approved, and that takes care of the problem for IRS. But don't put
That's
in
right.
conditions and buts and maybes after that. Go ahead, sorry.
Yeah, no qualifiers after that. It's simple. It's deemed to constitute denial. So moving on, we're going to then talk about the termination and extinguishment and proceeds clauses. It's another straightforward development, at least in the eyes of the IRS. In the language of the extinguishment and proceeds clause, we've seen a flood of cases in tax court recently, and it really serves as a warning to land trusts about what the IRS is currently focused on. So this slide is simply a reminder of the necessary elements to include in your termination and extinguishment clause. That the easement is a gift of a property right which has value. The value is a percentage of the value of the entire property at the time of the gift. If the conservation easement, conservation restriction is terminated or extinguished by a court, and if the unencumbered property is then sold, then the holder receives an identical percentage of that value. The holder must use the proceeds of the proportionate interest in a manner consistent with the conservation purposes as set forth in the regulation. So that's really just a reminder of the necessary elements for that clause. So here's a quick example. We have a $1 million property, donated conservation easement, reducing the value to $600,000. The easement represents 40% of the value of the property. Years later, a court extinguishes the easement when the landowner and the holder claim it is impossible or impractical. And those are elements from the regulation. The unencumbered property is then sold for $300,000. The holder is then entitled to, again, that 40% of the proceeds of that $300,000.
$3 million.
And the landowner receives the remainder.
It's a $3 million sale, just to correct that. That's up on that slide.
Oh, yeah, thank you. We didn't get a chance to do that one. So we're not going to go in depth, but what we've seen over the years is that the formula in the proceeds clause has deviated from the regulations, and the IRS and the tax court do not want to see deviations from the regulations. So this is an example. It's a common example where the subsequent improvements to the property are subtracted from the proceeds to the holder. Okay. In this example, the value of the subsequent improvements is subtracted from the holder's portion of the proceeds clause. The IRS and the tax court have determined that this is a violation of the regulations. Another example is when the payment of the costs or expenses of the sale are subtracted, again, from the proceeds amount to the holder. Again, the IRS and tax court have said that this is not permissible. Okay. So
Diana,
what is permissible? Oh, go ahead,
jump
Steve.
in. And I think I would broaden that rules a little bit. I think really what the courts are saying is you start with the net amount after the sale. And number one, you can't take anything away from the holder's proceeds. But number two, you can't take anything off the top and then divide the proceeds. So you start with a gross number and first dibs, and Diana's going to get to that. No ifs, ands, or buts. First dibs is the holder.
Yeah, the bottom line for the court, for tax court and the IRS so far is, and the lowest risk option is just to simply copy the rules and the regulations, that no deviations are allowed. I will note, though, that there are 2 tax court cases on appeal in the 5th and 11th Circuit about the interpretation of the rules and the actual validity of the regulation itself, because we track the tax court cases right now. There are 150 that I've been tracking based on this proceeds clause challenge. And so this will evolve in the next few months to years. So stay tuned. So our current guidance as the Land Trust Alliance is, really the safest and the lowest risk option is to repeat verbatim the Treasury regulation language. And we have seen land trusts still try to be a little creative and just omit language concerning the subtraction of an amount from the calculation, a little bit of a higher risk. There is the IRS's Conservation Easement Audit Technique Guide, if you want to take a look at that to see how they actually are addressing this language in their review of audits. We hear from landowners who are upset about that one, about subsequent improvements specifically, not being allowed to be subtracted from that clause. If you're really concerned about that, you can weigh the risks about excluding build areas then from your easements as another option. That's a risk analysis that you all might want to consider. And we will talk about that option in a little bit more. Anything else to add on that one, Steve?
Yeah, two quick comments. And again, one, the risk analysis varies again depending on who the client is. Some of us have been told informally by IRS the agents are reading proceeds language in conservation easements and they are comparing them with the regulations. And if they aren't the same,
That's right.
they could argue deduction denied. And so to me, that's a high enough level of risk to say, okay, whatever the current law is, and these cases are on appeal, whatever the current law is, we're going to follow that. So we're going to have an absolutely clean clause. I think the other thing, and it's important to put this into context, the IRS started to focus on syndications, syndicated conservation easement donations, abusive tax shelter donations posing as conservation transactions. For every action, there is a totally unequal reaction. The syndicators and the promoters have put millions and millions of dollars into the pot for legal fees and publicity. And they are challenging the IRS and the Department of Justice, there's at least one DOJ matter pending, on every single front. And they are raising all kinds of arguments that normally in a conservation easement audit, I would not say on behalf of my client, by the way, the reg fails to meet the requirements of the Administrative Procedures Act, and therefore your position is invalid. Aside from the irony in that, in a normal audit, that wouldn't be an issue. But that's a big issue now because the syndicators have got millions of dollars in legal funding fee costs available, and the lawyers are throwing everything they can back at the IRS, which is another reason why these things are in flux. And Diana mentioned one of the issues they've raised is, well, this clause isn't valid under the Administrative Procedures Act. And this is not a seminar on that, but that's one of the consequences that seems to have popped up as a result of chasing the syndicators. So those are my quick observations there.
So do you want to lead us off now, Steve, on a discussion of about amendment provisions?
How much time do we have left? No, I'm kidding. This is one of, I think probably this is the most controversial and unresolved issue in the field today. In the beginning, and I would say this as the drafter of the regulations, we never even thought about amendments. It never came up. So anyone who says, well, the regs seem to imply such and such and so, maybe they do, but the question never came up. But it's come up since then. And the issue isn't what amendments do you as a land trust, as a conservation easement holder, allow? What amendments do you consider? What amendments do you not consider? You each need your own policies on that. Every single easement holder in this great country of ours needs its own criteria for what kind of amendments you'll consider, what you'll accept, what you'll reject, and what your due diligence process is. This isn't about that. This is about what's the language in the amendment provision in the conservation easement. And the spectrum has gone from at one end of the spectrum, there are advocates and recently some court language that says, well, an easement is just a contract. It can be amended by the mutual consent of both parties like any other contract. If that were the case, then there would be no federal income tax deduction available for any conservation easement, because none of them would be enforceable in perpetuity if there could be mutual consent. At the other end of the spectrum, in the beginning, the IRS was very much against amendments. Well, these are supposed to be perpetual. How can it be perpetual if you get amended? In fact, it was rumored that someone in the IRS said amendments should be illegal. Not quite sure what that meant. So what's evolved out of that is a couple of different things. And number one is the IRS was asked, and under the heading, be careful what you ask for because you might get it. The IRS was asked for guidance on what amendments would be not what amendment provisions would be audit proof, what amendment provisions would not cause the IRS to say, okay, we'll let that one go. And I think that's on the next slide, or it's on one of the next slides. There's a lag here in the atmosphere between clicking on a slide and moving it, so bear with us. It's not too long, it'll come up. Unless that's frozen again. Is that frozen again?
It's on my screen.
Ah, there we go. Okay. IRS Safe Harbor Amendment Clause. What this Safe Harbor Amendment Clause says is that many of the legitimate, I'm not saying they should be done, legitimate requests, thoughtful requests, interesting issues for amendments to conservation easements would not be considered at all under this IRS rule. This IRS rule is very, very, very restrictive. What it says is, if you copy this language, we won't raise the issue on audit that you lose your deduction because your amendment provision is too loose. But it also considerably narrows what amendments you can consider. And I would just point out the two asterisk parts there in the introductory language and at 2i. Grantee and grantor may amend this easement to enhance the property's conservation values or add real property. Okay, but what about if you don't add real property and you have an amendment that's, say, neutral in conservation effect? Can't do it. And 2i shuts down, well, you know, we'd like to put another barn in that building area because we find we really need it to be able to carry on our agricultural activities. Nope, you can't permit development, improvements, or uses prohibited by this easement on its effective date. Very, very, very restrictive. The IRS says, well, that's what we think. We think easements are enforceable in perpetuity and you shouldn't mess with that. And I have had clients that have insisted on using that provision because they didn't want somebody else messing with their conservation easement in the future. They wanted it to be tight and fully enforceable. But this is a tough provision to put in your easements. So under the heading of risk, what are some of the other possibilities? Let's see the Massachusetts template. And again, those of you who are in Massachusetts, you know, if you don't use the template, it's possible to not use the template, but it slows the process down. And this template's pretty good. I just point this out for the Mass people here. 3i, the grantee will consider amendments only to correct an error or oversight, to clarify an ambiguity, or where there is a net gain in conservation value. And little 5 there, shall comply with the provisions of Article 97 of the Constitution. And those of you from Mass understand that means that if you're if you're a charity or a municipality, government agency, and you're holding land and you want to release some of it, you need the approval of the legislature. So that by itself makes that pretty restrictive. But here's a suggestion of a couple of provisions that I would like to see added to both the mass template and your own templates. And again, these are from the perspective of keeping the IRS off your easement. One little I there. I guess people say that's Romanette I or one. All of the rules everywhere say that there cannot be any impermissible private benefit or private annulment with an amendment. You can't agree to an amendment that conveys more value on the owner of the property. That's a rule that applies to all charities. No private annulment, no private benefit. However, what the IRS likes to see, and we've been told informally, is who makes that decision. And one way to deal with that is to say you've got to review that question by a private appraiser, by a privately retained appraiser, generally, of course, retained by the land trust, although maybe by the grantor, but reviewed by the land trust. But you need an appraisal. The value issue is not something for lay people to determine. Same thing on the next one. It has a neutral or positive effect on the conservation values based on an evaluation of the proposed amendment on the conservation values by an independent qualified person selected by grantee. And so I think those are important. There were a couple more at the end. Can you go back one? I just want to point out, yeah, right there. That's the last 6 and 8 there essentially say, oh, by the way, while we're at it with this amendment provision, we're also making clear that you can't loosen some of the other restrictive provisions in this amendment, like the proceeds clause, like the amendment provision. And I think, again, that's a safety net, and that's looking at what the IRS might think about this. So my recommendation is to, in Massachusetts, start with the mass template, of course, and add these tighteners that I have up on the screen right now. But it's either that or the IRS safe harbor language. I haven't heard from DCS about the IRS safe harbor language. In any case, Article 97 of the Constitution is going to be relevant. And I think, obviously, if you do something other than the safe harbor language, there's a risk. So, Diana.
So thank you, Steve. We take a little bit of a different position. So in light of the tax court's perspective and the recent Pine Mountain Preserve case, the Alliance continues to take the position that inclusion of a modification clause, which can include amendment, consent, waiver, and other discretionary approvals, it actually improves the chances of perpetual easement protection. The bottom line for the Pine Mountain Preserve case was that an amendment clause is valid as long as it does not endanger the qualifications under the regulations. So I'll note that the Alliance did file an amicus brief in that case, and the court followed much of that reasoning. So on this slide is the recommendations of the Alliance in its amendment report. It supports the inclusion of a clause allowing for modifications that are consistent with the overall purposes of the easement. And that's really important. And it's obviously subject to the requirements of all applicable laws. So these are the concepts that should be embodied in that type of modification: clearly serve the public interest, consistent with the land trust mission, comply with all federal, state, and local laws, not jeopardize land trust exempt status, not result in private annulment or confer impermissible private benefit. We'll talk more about that in some of our examples later. Be consistent with the conservation purposes and the intent. Be consistent with the documented intent of the grantor and any direct funding source. Those sometimes can get forgotten, so they're really important. And then have a net beneficial or neutral effect on the relevant conservation values. And that too plays into what Steve was talking about earlier about the independent appraisal. It's also good to have an opinion letter from outside counsel about some of these factors. There are different ways you can do it, but these are basically the concepts for you all to consider. Any more comment on that one, Steve?
I want to point out, John's comment there that I think everybody could see. Thank you for clarifying that. Article 97 applies only to land and interests in land held by government entities. So that's another reason why I think the IRS could look carefully at the Mass template. And I can argue that maybe it could be a little bit tighter. And tighter in the sense of showing the IRS we know what we're doing, showing the IRS we're not looking for random amendments, but we're trying to preserve the possibility of doing something necessary in the future. A decade ago, somebody said to me, well, what if you need to amend a conservation easement in order to protect the conservation values in perpetuity?
Right.
And without going into possible fact patterns for that, that shows how complicated and how difficult this area is. If you do not use the IRS safe harbor language, then you need very, very, very restrictive amendment language, or you're going to be in trouble. And you might be in trouble anyway. And I also see Kathy's posted, there's also the option not to include an amendment clause. For a few years, that was my position when it was unclear what IRS was looking at and what they wanted. And LTA and I had a difference of professional opinion on that because they insisted on using an amendment clause. And I've come around to that latter position. The absence of an amendment, one of the purposes of an amendment clause is to set guardrails on what can happen with an amendment. And you may have your own policies, but it's one thing to have your own policies if someone comes in with an amendment you don't like. And it's something else to have an amendment provision in the easement. So no, Sally, sorry, we can't do that because the easement which you signed says we can't do that. Now, this is part of the amendment discussion. We're going to get to more of it later. I've said I think this is the trickiest issue. I think a level up from this issue is climate change and amending conservation easements. And we've got some examples at the end, and we're going to talk about actually putting amendment provisions into effect, but that's for later.
That's right. Okay, so we're going to jump now to location of future reserved building sites. Case law is still evolving on this issue. Steve and I are going to run through some options when it comes to reserved building sites. And this, again, is where your risk level comes into play. So let's start with what you can't do when it comes to future reserved building rights with a little bit of nuance, I would say. So number one, we talk about the fully floating building envelopes. Some people call them building sites, some call them building areas, some call them building envelopes. So fully floating building envelopes is where in an easement, the landowner can build a house or build an agricultural strip, whatever it might be, anywhere, that there are no limitations on that building site, okay? Number two and number three is where we're getting a little bit of evolution and some difference in the circuits on their perspectives on when a grantor reserves the right to build subject to the approval of the location by the grantee, by the holder of the easement. And that was part of the Pine Mountain Preserve case where the Federal Circuit Court did basically tell the IRS and the tax court that they were analyzing this incorrectly. And so right now it somewhat depends on the circuit you're in, but this one is a little bit nuanced, as is number three. identifying on exhibit future reserve build areas or building envelopes, but then the grantor has the approval. Okay, so we're seeing some evolution. Number 4 seems pretty settled though. No swaps of protected area with unprotected area, the swaps outside, and specific external boundary adjustments or land substitutions. And the courts have been pretty consistent about saying, no, you can't do those. Okay. So let's get into some options. Go ahead.
Let me make a comment about those last couple that Diana mentioned. The IRS and the courts that have decided in what I guess we'd call adverse to particular provisions, the position is this: you put a conservation easement on a piece of ground, you reserve the right to put a house over here. Every other acre of land is encumbered and protected and preserved in perpetuity. Period. No further discussion. Not an invalid perspective, okay? Therefore, if you reserve the right to move it, if you say we can put a house here, but with approval of grantee, we can move over here, then these acres that were protected in perpetuity now have a house on them. And there's some logic to that position. Going back to the other one about approval by grantee, I think the regs seem to bless that, but the IRS in recent years, I think, has come to trust less the tax exempt charitable community, in part because of the syndications, and they don't like that now. So you've got to be real specific. Diana, sorry.
Thanks, Steve. Okay, what can you do? Let's go through some options. You want to start off, Steve?
Yeah. One of the easiest options, I think, and I think the least likely to get you into trouble, or maybe the second least likely to get you into trouble, would be to identify limited building areas. And we'll have a slide on this coming up ahead of time. Here's the property, and Aunt Sally can put one more house here, or she can put one more house here, but she can only put one more house in either of those areas. And so you've maintained some flexibility for her. The issue that follows is whether or not building in those areas in the first place would have an adverse impact on the conservation values of the property. And I'm sure anybody from the IRS watching this, I'll say it anyway, I'm sure there are conservation easements out there that were done in very good faith, where the landowner reserved the right to put a house in an area that had an adverse impact on the scenic view, or had an adverse impact on habitat, or whatever it might be. And but all things considered, the people were happy to take those easements because it protected a larger piece of property with important conservation values. Alert, the IRS may be starting to look at this issue of exactly where these improvements are going to go. So if you do identify limited building areas ahead of time, then you also must support in the baseline documentation report, maybe also with some reference in the easement, the proposition that building in this area will not disturb any of the conservation values. We just did a big project in a southern state, and the landowner reserved the right to have a number of improvements, but they were all in what we called previously disturbed areas, where there had been buildings, or where there had been pavement, or where there had been whatever. So we could say with a straight face, building in these areas won't have any impact on the conservation values because they were already beaten up before then. Give grantor the flexibility, same idea, again, 2 building sites, and you can put one house in either one, or 3 building sites, and you can put 2 houses in any of the 2 of them. And we also now recommend, or at least I recommend, I don't speak for LTA or IRS or anybody else but me. I recommend that if Aunt Sally chooses to build in this limited building area, that you amend the conservation easement document simply to extinguish the right to build in the other building area. And as an amendment, I know people don't even like the term amendment, but I can't speak for the IRS, but I think that's prudent. So, okay, next slide.
And this is our 15-minute warning, Steve, until the Q&A portion. So just letting you know.
Then let's go to the next slide.
Okay. The map.
This illustrates what I just talked about. And I don't know if you can read it on the screen, but in the lower left center of the property on the road is Sally's house. And the easement has carved out a limited building area around Sally's house where she can mow the lawn and fix the garage and so forth. And so that's already there. That's a pre-existing improvement. And the regs say that if there are pre-existing improvements that have no adverse impact on the conservation values, that's fine. And so that works here. Sally wants to build one more house. Okay, she can put it either in the area in the lower right of the map or in the area in the center of the map. Those are the two reserved limited building areas. And we previously determined that there are no significant conservation values in any of those areas, or if there are, they've been disturbed. So I'm going to wrap this up just with a comment that this is one way to do it. Now, Diana mentioned before, it's also possible, if you're nervous about the IRS or nervous about this issue or any of these, to leave out of the conservation easement, not encumber the building areas, but have them cutouts. So they're not encumbered by the easement, which doesn't threaten the deductibility of the easement. I would further recommend that if you're going to leave cutouts, you put a non-deductible easement or some other form of perpetually enforceable restriction on those cutouts so there can't someday be a gas station there. Single-family principal residences, something like that.
Yeah, just to add on to that point, there are complications with the so-called cutouts, and you really need to think about stewardship issues down the line when it comes to cutouts. So in the interest of time, we'll keep moving.
Let me just mention that I think Diana's comment is worth repeating because it emphasizes this is an area that's very much in flux. The court decisions are very much in flux. There's no clear answer about the best way to do this. There are some steps that you should follow, but we're sorry we can't give a more specific answer. But if you're aware of the issues and aware of the problems and you do your job, you can figure out how to handle, because every situation is different. Okay, now the easy stuff, right? Climate change. Let's go forward one slide and then we'll come back to this one so we can get a visual ahead of time. Okay, here's Sally's property. It's the ocean, the beach and the ocean at the bottom of the screen. The red is the boundary of Sally's property that's encumbered by a conservation easement. The tan area in the lower right is where the existing conservation easement reserved the right to build a house. Okay, and now we can go back one slide, Diana. And what's happened, Sally put the conservation easement on the property in 2007. She hasn't built on it yet, but she reserved the right to put one more house in that designated location. Very long story short, there's been considerable erosion since 2007, and particularly in Massachusetts and Rhode Island. Those of you who've done easements with property along the water, of which there's quite a bit in both states, both property and water, this is an issue. Some landscapes are not susceptible to erosion. There's been accretion, but there have been a lot of erosion situations. And I'm dealing with one right now with a client who put a conservation restriction on a piece of property, thought he would get a much larger deduction than he's going to because the appraiser said the erosion problem here is very significant. Okay, so now we go back to the slide, and it turns out that Sally's lost about 200 feet, give or take, of a building area. There's been considerable erosion on the beach. So maybe the useful life of a building in her reserved area is very limited, and nobody would probably do it. So Sally wants to move the site to the other location. Go back one to that one there. And again, note in this slide that the land trust owns property across the road. Okay, and that's important because the next set of facts gives us exactly the same situation. Go to the next slide, and you can compare. In this one, Sally owns the land across the road. Okay, so the first question is, if the land trust owns the property across the road, can Sally amend this conservation easement to relocate the house site? The first answer is, well, wait, isn't that a more valuable house site? Isn't there some private benefit to Sally, and therefore we, as an easement holder, can't agree to that? We're sympathetic, but the house site near the water is almost valueless, and the house site further back isn't. And so that's a stumper of a question, and I think that's unfortunate. And I always say there are two buckets here. The first is those easements that have already been recorded, and we can't do anything about what those terms are. And the next bucket is the ones that haven't been recorded yet. And we don't have a clear solution to this climate change issue, but I have something to suggest once we get to the next slide. So this one, unfortunately, looks like the answer is no. I'm sorry. Now we're doing the one where Sally owns the property across the road instead of the land trust. And this raises a very controversial and complex issue in the land trust community, and that is, can you net off any gain or loss in conservation values with something else? The idea here being, okay, Sally will let you move the house to the back of the property, but we want an easement on 20 of your acres across the road. And that easement is worth more than the benefit from the new house site. Oh, and by the way, that's not deductible, that other easement. That's a quid pro quo. That's part of the deal. We will let you do that, however. In the beginning, when we got into this four corners so-called issue in question, I didn't like that idea at all, because to me it was tantamount to buying your way out of a perpetual conservation easement. And if the issue is, okay, we want you to encumber more land, well, what's the difference between that and Sally saying, I don't have any more land, but I'll write you a check for $100,000. Oh, and by the way, I know that's not deductible, but that way that nets out any private benefit that I might have. And very strong differences of opinion in the land trust community. One veteran land trust person says, absolutely not. I'm sure many, absolutely not. We can't do that. And I've had others who've said, if there's a net conservation gain, we're for it. And there's no official answer and no official law from IRS on this.
And that's going to become even harder with climate change. I think that weighing of that neutral benefit, that's going to become incredibly relevant with issues with climate change.
I have drafted, and as I told Diana earlier, I didn't make a slide out of it because I didn't want people to take a screenshot. But I've had some thoughts on language for conservation easements on climate change. And essentially, I would say a proposed amendment that's under consideration on account of climate change, there's more to it than this, which impacts have made impossible or impractical a certain reserved rights in the easement, and the parties agree to amend it, they can go to court and get the court approval of doing that. It's sort of like terminating an easement. They can't do it themselves, but they can go to court and let the court do it. And I would add, in a situation like that, grantee's share of the proceeds won't be diminished. Whatever the share of the proceeds was in the original calculation, that's what it is here. So it's like terminating an easement and replacing it with another one. That's not legal advice. There's no guidance on that. But this is a problem we in the land trust community have to figure out how to handle. Diana.
So in the last couple minutes, we're going to have Steve walk us through syndications really quickly. We're going to mention 30 by 30, and then Steve is going to end with one last tip. So you want to go ahead about syndications?
I will take as much time as it takes to move to the next slide. Without spending any more time on this, most of you know what these are. Stay away from them. They're marketed transactions where you put in $10,000 and you get a $100,000 deduction. And it's a tax shelter, and it's based on grossly inflated appraisals, and the IRS is after these. Next.
Okay, so we just wanted to flag the president's executive order on 30 by 30 and the important role of voluntary private land conservation. As you all probably know, the goal is to conserve 30% of U.S. lands and waters by 2030 through a variety of means and tools, including voluntary land, private land conservation. The executive order that Biden signed directed the Department of Interior and Ag to submit a report, I think it's April 28th, yep, on recommendations and findings related to achieving 30 by 30. And in the words of the Interior Department, that report is expected to outline a broad set of principles by which the administration can pursue a broadly supported, inclusive, and locally driven conservation agenda. So apparently the Biden administration is currently convening meetings related to 30 by 30 with stakeholders. They're just starting that process. You know, that's ambitious to have something, that kind of report by end of April. But we did just want to flag that there might be increased opportunities. It's a very ambitious goal, and those meetings are just starting. So hopefully we'll have more detail on the actual plan and implementation by the end of April. But we're certainly gearing up to create those opportunities and how we will be able to meet those opportunities.
And without committing LTA to anything, because I don't have the authority to do that, but I'm sure they're going to be at the table.
We are doing our best, yes.
I have one very quick observation about that, and that is for the past 3 decades, land conservation in this country has grown enormously with conservation easements and with government funding. And I think the 30 by 30 number is something like another 450 million acres of land. Whether it's that or another 100 million or another 50 million, we need a bigger toolbox. Nobody has yet come up with some additional creative ways to save resources. And I'm thinking about things like carbon credits. I'm thinking about things like water credits, which don't really exist much, or habitat credits, or green credits, or urban garden credits. Not going to make a big dent in 450 million acres with urban garden credits, but the point is there has to be a way to get more money. Whoa, he's talking about our capitalist system again. Yes, there have to be ways to get more money into private money, hundreds of millions of dollars of private money into private land conservation efforts in new and creative ways that attract that money so we have socially responsible investing.
Yeah, and one other comment about 30 by 30, part of what the Alliance is trying to do as well is that making sure that 30 by 30 remains in the sights of the federal agencies when they have other goals like the expansion of large infrastructure, linear infrastructure, that how are you going to weigh that goal with the goal of 30 by 30 and making sure that 30 by 30 remains a priority in addition to that infrastructure goal. So just a comment. So I think Steve's going to end us on one last practice tip, and then we'll go to Q&A.
Yeah, very quick practice tip here. I recommend, and others recommend, the goal here again is if the IRS reviews the grantor's tax return, and particularly looks at the conservation restriction, conservation easement material. They review it, they read it carefully, and they put it in the outbox. Something devoutly to be wished. Okay, those of you who haven't been in an audit, count yourselves as lucky. So you need the completely executed Form 8283, properly executed, follow the instructions, fill in all the boxes. You must file that. You must file a supplemental statement along with it. That's required for easement donations. You must file a qualified appraisal if your claim deduction is greater than $500,000. And frankly, I recommend filing the appraisal anyway, as long as it's a really good appraisal and it looks good and the appraiser understands how to appraise conservation easements. The IRS likes to see filed, it's not required, but they like it, a copy of the recorded conservation easement. And most of the time that's in the qualified appraisal report, but if it's not, added with the tax return. And by the way, you're saying, wait, we don't file tax returns. Land trusts aren't supposed to give tax or legal advice. Right, I understand that, but you're not supposed to hide your heads in the sand either. And if there's a way that in your infinite wisdom you can make this process easier for the landowner, I recommend you do that. File the baseline documentation report. Not required by IRS. IRS likes it. File the baseline documentation report if it's 2 or 3 pages and incomplete and doesn't look good. No. Put more emphasis on the baseline documentation report and include photos and include habitat inventory. And many of you do this anyway, but file it. The contemporaneous written acknowledgement, everybody knows, get the damn gift letter. And if you have the gift letter, file it with your tax return, not required. But what does that mean? It means the IRS won't call you or write you a letter and ask to see if you have a gift letter. And for them to open a file and put your name on it and call you and write your letter, it's all downhill from there. So file that. We've also been advised, last tip important, there's a different contemporaneous written acknowledgement requirement for cash donations. This is any cash donations, but obviously it could apply to stewardship contributions. You still need the gift letter. And that's, again, the responsibility of the donee of the gift. But the donor also must have backup documentation of the cash gift. Now, is that difficult? No, a canceled check, a bank account statement. And I asked the question of IRS, does this mean, they said they're going to be emphasizing this. I said, does this mean that people are claiming tax deductions without having made them? And I got this huge laughter back. In other words, that's the issue here. I recommend that the donor include a copy of the gift letter for the cash gift, for the endowment gift, and staple to that a copy of the canceled check. And that way, again, the question doesn't come up. The IRS looks at it, you've met it. For those of you who are gluttons for punishment, that's section 170F17. The contemporaneous written acknowledgement is 170F8. This is F17. Most people have never read that. I'm done, I think. Diana, you have some closing comments?
Steve, I'm so proud of us. We have 10 minutes left for questions and comments. So I'm going to start off in the chat. Mark Robinson wrote about 30 by 30 improvements. Allow landowners to take the expanded deduction. Available for conservation easement donations when they donate land and fee, and eliminate the 2018 rule that requires IRS to reduce deductions by the amount of a state tax credit when land or conservation easement is donated. And that those SALT rules and regulations have become quite controversial. So I think that might hopefully change in some time. So let's go ahead and move over to Q&A.
And I think, by the way, that's a good suggestion as far as under the heading of 30 by 30, the SALT rules, state and local tax deduction that Diana mentioned and that Mark asked about, are controversial. This is a good reason either to do away with them or to somehow exempt conservation easement donations from the calculation or something like that. The small rules can be very painful for people in the Northeast with in high tax states.
Okay, so the first one we have from Beth Finch is the IRS stricter in excluding the value of an easement at the death of the donor rather than at it is at the original donation?
Read that again for me.
Is the IRS stricter in excluding the value of an easement at the death of the donor than it is at the original donation?
Well, if the question is if you donate an easement by will, I'm not sure that's the question. If you donate an easement by will, which is absolutely possible, as is a post-mortem easement, every estate tax return gets audited, I'm told. And so therefore that increases the likelihood that there'd be an audit there. I have not run into any situations yet where there's been an easement audit in an estate tax context. If the question is, if you put the easement on during lifetime and take an income tax deduction and then you die owning restricted property, the easement doesn't show up anywhere on your estate tax return. And what shows up is the value of the restricted property. And if you include an easement in your will, the full value of the property is included in your estate. And then there's a charitable contribution deduction for the conservation easement. So same bottom line result. But if you're doing an easement during lifetime, it doesn't show up really in the will anywhere.
So the next one, and this is a hot topic certainly that I'm happy to chime in. Robert Bowers asked, we're working with the NRCS on a potential sale or donation. Can I depend on them to supply appropriate conservation easement language?
No. The answer is no. And that's a great question, and I'm glad it's come up. Many government agencies at the state and local level have language in their templates, and we don't change that, and we won't change that. That's contrary to the current rules. The most typical that I've seen in Interior Department programs is the parties with the consent of the secretary can terminate this easement. And that sounds pretty good, and it sounds pretty official with the consent of the secretary. And I've said, no, that doesn't work. That's not what the regs say. But what we've come up with in those situations is with the consent of the secretary and agreement to the termination, the parties can go to court and get the easement terminated. So you need to look very carefully because there are a number of federal agencies that do have provisions in their easements that are contrary to what is currently required. This problem was raised with IRS a few years ago. The answer was, yeah, we know that. We think maybe we're going to try and convene a meeting, but nothing's happened. So it's a very important heads up. Read those documents carefully. And if you work hard enough to explain to them and point out in the regs what the rule is and craft a reasonable solution, we've had success with that. But you've got to catch it and be reasonable in the first place.
Yeah, and I'll just add on to that when I worked on agricultural land easements through the NRCS and USDA programs, they have minimum deed requirements. And so when a land trust and landowner receive those minimum deed requirements, you instantly think, well, I have to follow this template or it won't be approved by NRCS. But in conversation, and they'll have included, the minimum deed requirement will include fully floating building areas. And other provisions that would trip up the IRC and the regulations. And so when we would go back to the NRCS representative or the field officer, we would point this out and they would say, look, we're really sort of relying on the landowner and the land trust to point these out to us, and we need to talk about these and negotiate. On the other side, we've heard the IRS say, just because it's a state agency or a state government or another federal agency, they are not experts on tax. And so just because it's a government agency or in some form does not mean that they are going to meet IRS regulations for a deductible easement. So you really, as Steve said, you have to really parse it out and make sure you're looking, especially at that boilerplate language too.
And I would add this, and Diana's point is very well taken about the IRS saying, we don't care what the state agency says, or we don't care what the federal agency says. We look at 170H. The classic example of that is the case in Maryland. Doug Carroll conveyed a conservation easement, and he got one word wrong in the conservation easement. I won't go into the details. And the deduction was denied. And one of his arguments was the Attorney General's office in Maryland has blessed this form. We've been using this form in the Maryland Environmental Trust for 5 years. And the IRS's response to that is, that's not relevant. What's relevant is what our requirements are. And I've also been in situations where we've pointed this discrepancy out to an agency, and they say, well, no one's ever raised that before, so therefore you must be wrong. And my answer, I raised it before, but I'm raising it and we need to fix it. So you may hear that and stick to your guns if you want to protect the landowner from a terrible, terrible fate. What could be worse? There could be worse things. Beautiful conservation easement, beautiful property, big tax deduction denied, property fully restricted, all that value gone. So we want to try and avoid that.
So that looks like that's it for the Q&A, Steve, and we just have 2 minutes left. So any parting remarks?
Yeah, back to where we started, that the field is very much in flux. 10 years ago, if a client said, will this conservation easement qualify for a deduction? And my answer was yes, because I wouldn't do it if I didn't think it qualified for a deduction. Now, if a client says, will this conservation easement qualify for a deduction? My answer is, it complies with the current state of the law as we understand it today. That doesn't necessarily mean that the IRS isn't going to raise new arguments, that court decisions are going to change and so forth. But this is the best that we can do today. And that's a very difficult situation to be in. That hasn't discouraged any of my clients yet. But it does show how much things are in flux. And as I've said, the lazy, hazy, crazy days of summer are over. And this work is much harder and much more difficult than it used to be. And we're glad that those of you who are watching took time out on a beautiful Friday morning to